It appears that you are presenting a lengthy and intricate essay concerning the legal justifications for disqualifying Donald Trump from the 2024 presidential elections and the decision of the Supreme Court in this regard. There has been a definitive resolution to the legal challenges to the inclusion of Trump in the 2020 presidential elections, with the goal of ensuring clarity and proper punctuation. Everyone was satisfied with the ultimate ruling that the Supreme Court gave today. This little video will explain everything. To preface this video, I'd like to emphasize that we do this every single day, so if you're interested in politics and want to stay abreast of what's happening in the US, all you have to do is hit the subscribe button. Since Section 3 of the 14th Amendment states that an oath-taker cannot be included on a state's primary ballot, I am grateful to the Colorado Supreme Court for removing Donald Trump from that ballot, in defense of the United States Constitution. And then it rebelled against the administration, which was unable to carry out its duties and came under heavy criticism. A similar response ensued in Maine after the Secretary of State there followed suit. The majority of the complaints against these choices are unfounded and require redress. One of the 6 most prevalent and false accusations is that Trump did not receive due process and that Congress should take action to ensure it. A conviction on one's criminal record following an indictment is the only way to avoid disqualification. It is unfairly undemocratic that Tired 14.3 does not incorporate the presidency as a result of its stipulations. The assertion that the government must take some kind of action is the most easily disproven. According to the majority judgment in Colorado and a few constitutional academics, 14.3 is self-enforcing in legal terms. Therefore, it does not require a law for implementation according to its terms. This, however, is the moment to get Congress to take action. During the second impeachment hearing in 2021, the House majority of senators and representatives found former President Trump engaged in the same behavior outlined in the article of impeachment, labeled incitement of insurrection, with a ratio of 14.3. Of course, the Senate failed to reach a conviction by the required 2/3 majority following the House's impeachment. Having this in place would make running for re-election impossible. Nevertheless, it should not be ignored that 57 senators voted to convict Trump and confirm his performance of the acts listed in Article 14.3. There is no doubt that Donald Trump is entitled to due process under the Constitution. The issue at hand is, how much is due, and what exactly does it involve? Unlike criminal prosecution, which necessitates more stringent requirements and an appeal, the procedure for removing ballots is a civil matter in this new environment. Colorado's election law imposes stringent deadlines for pretrial proceedings, trials, and appeals, as the primary must be certified by January 5. Permit further procedures for due process. That is right. However, this does not mean that Trump is being denied the constitutionally mandated due process. The aforementioned impeachment proceedings in 2021 included extensive due process, so keep that in mind. The majority of the Senate jury found Trump guilty, despite his attorney's best efforts to defend him. The claim that a criminal record is necessary for disqualification under Section 14.3 is presently before us. There is no evidence in the language or context of 14.3 to support this. This is a typical distraction, and we must remember that the majority found that Trump did the acts outlined in 14.3 in the second impeachment of the former president. To put it another way, remove the grounding. Does a conviction after an indictment constitute the sole available option? If the framers of 14.3 believed that impeachment was the sole option for dealing with a former president who was an insurrectionist, they were surely familiar with the impeachment provisions in the Constitution. That is what they would have stated. It is quite unlikely that they considered this possibility. This leaves us with the straightforward interpretation and practical implications of verse 13. What exactly does it mean to be a United States officer? Does the president fall into this category? The trial court in Colorado was unwilling to expand the meaning of the term to encompass the presidency, which led to its ruling. Not everyone on Colorado's highest court was hesitant. The court, assuming the president to be an official of the U.S., highlighted multiple references to the presidency in the Constitution. Since the majority view extended beyond mere semantics to the plain meaning of the text, the gravest criticism is still outstanding. Using Section 14 to oust Trump would be blasphemously anti-democratic. The issue at hand is not one of law but of politics or political law. On this matter, what is your opinion? Please share your thoughts and opinions in the space provided below. $370 million in fines and a lifetime ban from New York's real estate market await the ex-president and 2 of his former company executives. That is according to Letitia James, the Attorney General of New York. The plan is a component of the motions after the trial has ended. Attorneys from James's office allegedly saved $868 million in interest via deceitful means and an additional $52 million from the sale of the old post office building in Washington, D.C., which is home to one of Trump's hotels. NBC News reported that the filing occurred on Friday, January Fools, 2024. Additionally, James is seeking $60 million from the sales of the Ferry Point Golf Course and $2.5 million from the severance packages. Among them are Alan Howard Weisselberg, who served as CFO for the Trump Organization, and Jeff McCann, who was the controller for the same entity. The Attorney General is urging a permanent injunction against all matters pertaining to the real estate industry and any connections to organizations or entities in New York. Injunction against. On the basis of the summary judgment, I will also suggest banning Trump, Weisselberg, and McCann, as well as his sons Donald Trump Jr. and Eric Trump, for a period of 5 years. The court convicted the president, his companies, and high-ranking executives on numerous counts of falsely creating and certifying Trump's financial statements. The alleged exaggerations ranged from $880 million to $2.202 billion. In their own motion, the defense stated that they had reviewed the financial accounts and found insufficient evidence to prove that any party intended to cheat. Their other concern is that the Attorney General has not been able to demonstrate insurance fraud or the practical effect of truth. As he claims that his financial claims are conservative, Trump strongly denies any wrongdoing and rejects the lawsuit, describing it as a politically motivated witch hunt. He plans to challenge the decision in court. Last month, the trial that started in early October concluded with the closing statements. The attorneys representing the two parties will present the final arguments on January 11. Gorin and Arthur are expected to release a detailed ruling outlining Judge Arthur's conclusions within the next 3 weeks. Gorin decided on December 18 that the Trump team's assertions of inflated financial data were finally resolved. Personal opinions. This commercial fraud case is among those in Florida involving the improper handling of secret materials and in Washington, D.C. In 2022, the initial damage estimate for Trump and his firms was $250 million, according to the Attorney General. But her $370 million punishment is more than that. Trump has continued to deny wrongdoing, blamed the AG of prosecutorial misconduct, and painted the legal proceedings against him as politically motivated in light of these developments. This legal drama will conclude with the judge's ultimate verdict. The court tussle has intensified as Trump attacks the Attorney General for pursuing $370 million, alleging that corporations are departing New York on social media. Claiming it's a DOJ witch hunt, he says prosecutorial misconduct is at the heart of the problem. James did not expect the sought-after penalty to be that high. Therefore, the dangers are substantial in a broader context. Allegations of the inappropriate handling of classified information have entangled Trump in a complex web of legal issues. The legal landscape is intricate and far-reaching, affecting territories beyond New York. The decision on what Trump does with his life after becoming president is imminent. The Hill reports that Representative Marjorie Taylor Greene was fined $122,000 by the Federal Election Commission as a result of these judicial actions, which occurred on Saturday, January 6, 2024. The Federal Election Commission appears to have unlawfully packed hard packs for political action committees. The conciliation agreement, recently made public, provides this information. The Federal Election Commission claims that Greene solicited non-federal funds in violation of the 1971 factor. It all started when her official Greene for Congress social media accounts published an ad. Promos for Greene's 2021 Senate runoff campaign initially surfaced online, on YouTube, and via social media. Written in December 2020, these accounts detail the current state of socialism. These elections ultimately led to the victory of Democratic Senate candidates Jon Ossoff and Raphael Warnock. A shocking confession and a request for compassion from Donald Trump have just rocked the globe. According to a legal expert, Donald Trump essentially admitted guilt during his speech in New Jersey over one of the federal counts against him in the grouped court case. In response to the remarks made by the ex-president following his not guilty plea to 37 federal counts in Miami, Florida, today, former FBI General Counsel Andrew Weissmann was speaking. These accusations stem from special counsel Jack Smith's investigation. While denying the federal allegations, Trump attacked Smith, calling him Ian Thug, at his Bedminster estate. Furthermore, Trump claimed that he had every right to retain the numerous boxes of classified information and personal possessions that he found at his Mar-a-Lago resort after leaving office, citing the Presidential Records Act as the rationale. The Watergate controversy involving Richard Nixon prompted the passage of the Presidential Records Act, which mandates the transfer of all presidential records to the National Archives upon the president's departure from office. Since they are property of the federal government, in an interview with MSNBC, Weissman, who was involved in special counsel Robert Mueller's investigation into Trump's ties to Russia, said that the former president's statements regarding his plan to retain the documents related to the charges against him may be construed as an admission of guilt. Still, those things count as confessions if he testifies in court. A portion of his statement is merely an open confession. In fact, it isn't even a defense. Weissman called it an admission. Regarding the allegations of improper detention and possession of documents, he further stated that he could seize these items. Asking, "Hey, you want to know why I took these?" is a complete and utter foolproof technique. Since I could remain in the loop. We're here to keep you updated on every turn of this story, and it's about to become hot. Leave a comment with your ideas, and hit like and subscribe for more updates. The Supreme Court has already made its decision on whether Trump can be disqualified from running for president in 2024. This brief film will startle you with the ultimate choice. Allow me to unravel it for you. Before I begin, I just wanted to remind you to subscribe and enable notifications if you find anything intriguing. Personally, it would matter. I appreciate it. Last Friday, it was rumored that the Supreme Court might consider prohibiting former President Donald Trump from running in 2024. According to the AP, the Supreme Court will consider a Colorado complaint alleging Trump's involvement in the events leading up to the 2021 January 6 attack on the nation's capital, regardless of the 14th Amendment. Trump asked the Supreme Court to intervene after the Colorado Supreme Court prevented him from voting last month. The Colorado Supreme Court excluded Trump from the Republican primary by a 4-3 vote. Hillary Clinton and the Democratic Party benefit, but Donald Trump's re-election bid suffers. Maine Democratic Secretary of State Shenna Bellows will rule next. The verdict prevents him from running for Maine office on January 6, 2021. The AP reports that judges must review the case before Maine and Colorado may decide. For the first time, the Supreme Court will debate the 14th Amendment scope. AP reports that the 14th Amendment's third section prohibits this. Rebelled against office. This rarely used amendment was enacted in 1868, after the Civil War. No facts existed for the Supreme Court to interpret the 14th Amendment. Congress enacted the amendment on June 13, 1866, and ratified it on July 9, 1868, giving all U.S.-born or naturalized citizens equal protection under the law. Among them were free blacks and ex-slaves. The third clause of the amendment is the disqualification clause. The New York Times reported that the statute aimed to limit the power of former Confederates during Reconstruction. The paragraph states that people cannot serve as senators or representatives in Congress, presidential or vice presidential electors, or civilian or military officials in the U.S. or any state where they have served. No public official, whether sworn to preserve the U.S. Constitution or serving in a state legislature, executive branch, or court post, may participate in or support an insurrection against it. A two-thirds majority in each chamber of Congress can abolish this disadvantage. That portion intrigued Eric Foner, a notable Civil War historian, as Congress considered impeaching Trump following the events. January 6. Foner's work on the American Civil War includes Reconstruction, 1988, America's Unfinished Revolution, 1863, Fire Trial, 2010, and The Second Establishment, How the Civil War and Reconstruction Remade the Constitution. He was appalled when demonstrators climbed the fence and stormed the Capitol. I watched like everyone else. Foner told the Washington Post he was surprised. Foner then checked if Klaus repealed the 14th Amendment. Only those who researched that array knew about it, Foner told the Post in 2021. Despite what the Post reports, numerous historians have emailed me that Article 3 would not apply if Trump committed a crime and that Section 3 may not have been effective in removing him from office almost 3 years ago. Future demonstrations of politicians' responsibility can deter them from supporting the Capitol assault. It will also be easier for lawmakers to approve. The Senate's 2-3 majority was insufficient to impeach Trump, but he resigned. A simple majority in each house can approve Section 3. The president will be unable to perform future tasks if Congress declares Trump a seditionist or rebel. Indiana University School of Law professor Gerard Magliocca will talk. The claim is that lawmakers believe Section 3 applies if Congress votes by majority. The court should then issue a formal proclamation. Maggio told the Post Congress that it can do more. Section 3 provides an appeals process if the legislation passes but challenges fail. Trump may run for president again in 2024 if Congress fixes this problem with 2 to 3 votes. Please vote in all legislative chambers. Section 3 is the only clause that prevents the president from pardoning without impeachment, according to Magliossa's December 2020 67-page paper. Magliocca writes that it shows Congress's hatred for President Andrew Johnson, who proposed the 14th Amendment in 2020. President Johnson's pardons of former Confederate soldiers infuriated important senators and state representatives, who refused to provide disability payments to any president, even Johnson. Except for the 1919 Reconstruction era, Article 3, Section 3, has only been invoked once. The Post reported that Congress expelled Wisconsin socialist Victor Elvsberger for opposing U.S. engagement in World War I. We really appreciate your patience in watching to the finish. Please comment on this news story, subscribe, and give us a thumbs up. Watch for our next news update. America may receive blessings. Bye.